May it please, Manoj. Manoj, two submissions. Please have a look at the first counter affidavit filed by them at page 2. Incident happened after 2:45. May kindly note. Please have a look at the first counter affidavit filed by them.
On dated, first counter is dated?
Manoj, that is on 12th of May 26.
12th of?
May 26.
Yes, sir.
Manoj, may I have page 2 of that?
2. Yes.
So I want to show the time of the incident. Based on the said secret information, the police authorities had, and before that, I just want to place one information. Vishal is neither an accused nor a witness. This is very important.
He is in a separate FIR against prohibition, my lords.
Prohibition, but not in. Yes.
Yes.
Based on the secret information.
What do you want to say of this?
So, Mala, the incident happened after 2:45. They themselves saying in the counter. Now, please see charge sheet also at page 56.
56 in your
In the SLP paper book.
Yes. Understand it is of fine. It is of
So what they say is that was coming from Kharbat Country Liquor, Ahmedabad City on dated and around 2:45. Right, my lords? So incident happened after 2:45. Now please see the chart filed by them. Page 4 is my phone number, which ends with 667.
filed by them in counter affidavit.
Yes. And Rupesh's phone number is 1991, my lords. Now
Page
please.
number 4.
Yes, so this is just want to show the phone numbers, my lords. This, my lords, have already been told to. So my phone number ends with 667. Rupesh's is 991. Now at page 17.
667 is of yours.
My phone number is
667,
667, yes.
All right.
And Rupesh's is 1991 in the end. Now please come to page 17
Where
of
is
this.
that 1991?
My lord, that my lords would find at page 36 Rupesh's phone number.
Page 36.
6. And my phone number as per their chart is at page 4.
Page 36.
Yes.
Number of so and so 991.
Yes. My lords have seen that? It says Rupesh.
Name mentioned.
My lords may say it's a 5-6 column, not Rupesh Ramesh Bhai. And at the top, my lords is the phone number.
Yes, fine.
Yes. And at page 4 is similarly, my phone number is there if my lords want to have a look.
Yes, sir.
Yes. Now please come to page 17. I spoke to Rupesh last at 1:31. Please see page 17. And this was noted by the High Court at page 70 also. Please see at page 17. My phone number would be this one. My phone number is at the left, which ends with 667 at serial number 1, 2, 3, 4, 5, number 7. I spoke at 110, then at 131 and 131. And they themselves say in their counter affidavit and the charge sheet, the incident happened after 2:45. So I could not presume that after 1 hour, someone will stop the car, and before that, and 1 hour before, I had told them, you please crush someone.
Let's understand. Who was the person found on spot?
Rupesh.
And Vishal.
And Vishal is not an accused in this matter. Neither a witness. Please see the charge sheet. Who are the accused and the witness? Not an accused, nor a witness. And they are harping on Vishal. So my submission is, please see page 49 charge sheet. Who are the accused in this matter?
Page 49.
Yes.
One is Rupesh Kumar.
Number 1 is Rupesh Kumar. And I am at page 53. Number 2.
Page number 49.
My lord, yes, page 49, my lords would find this chart over the page. My lords may say accused Rupesh Kumar at page 50.
Rupesh.
Yes, now please come to 53. That is me, Bhupendra. So there are only 2 accused. And I spoke to
Not a witness.
and he is neither a witness, Vishal, strangely. And now, my lords, the stage in this matter, my lords. So I last spoke to him at 1:31, incident as per charge sheet and as per their own counter after 2:45. So I could not presume that someone will stop a car and I would have given instruction to crush someone. And please,
Vishal is not an accused in this case.
no, Vishal is not an accused. Now,
Vishal is not an accused.
Vishal is not an accused.
Not in this case, because the charges, my lords, it's 302, 307, 333. My lords, quad the Prohibition Act, there is another FIR lodged, my lords, wherein he is accused for the same, on the same date, same incident. So
Now-
because, my lords, the car, he was acting at the behest of the petitioner, my lords.
It should be. Okay. Okay, after approval of the record in this CDR. learned counsel for the petition on the basis of the evidence. Learned senior counsel for the petition on the basis of the CDR summons. That the story was brought in by the prosecution department, commission of the offence by the accused, while the petitioner was on conference call, cannot be correlated with the CDR details. Full stop. Since the timing is not much. This time. On the other, when it comes to the state, seriously opposing the prayer summits, it proper time with the accused with Vishal. The peace to of 10-15 minutes prior of commission of the offence. Therefore, the possibility of commission of the offence cannot be ruled out. Listen, after reviewing the conflict from the parties, we find that the Vishal is not an accused in this case. However, the relevance of the CDR, if any, may be looked into, established by prosecution during trial. Listen, this is this. Petitioner has already served in custody since last more than 2 years and 3 months.
Yes.
And the application for discharge filed by him is valid. However, without expressing any opinion in light of the case, we will prepare to release the petitioner.
So grateful, Manoj.
Obliged.
Tips in item 3.1, I seek for a short accommodation. The AOR is down with high-grade fever. Just for today, if we can be accommodated. 3.1, the tag matter.
They were taken to be taken up together. My lord, if it can, it
They were taken up together, Your Lordship.
Our counter is also ready, my lord.
My lord, can I just say this? Please.
Tested, sir.
No, please. Just.
We are ready to assist.
My lord, on Thursday when this matter came up, learned ASD said a counter is being filed. We waited for it till yesterday and today it's not come. If he gives it to me today, your lordship may take it up tomorrow. I am willing to do it today. I am not asking for a date today also, my lord, in item 3. So, let him give it to me today.
3.1, just one day.
Tomorrow you can come. My lord, she'll come tomorrow. My lord, please, this is a bail matter. Your lordship may have it tomorrow.
Not tomorrow, my lord, Friday, my lord.
My lord,
Friday I cannot list.
yeah, tomorrow please have it, my lord.
My lord,
Cannot list for Friday.
I am going to see my father, my lord, but not today, my lords. I have some difficulty.
Vacation.
Lordships.
My lord, please.
Yes, my lord, let it come. Let him come.
My lord,
Or, my lord, it is such a case, my lord, that it can come even after vacation.
no, my lord.
Because the person, my lord,
application will.
no, my lord, they are playing with the society, my lord, in the cover of license.
So my
They are
learned friend,
playing with the life of thousands of persons in the society,
so
my
my
lord.
learned friend does not want
Such
to ask
person
you
and
to matter,
home,
and
yes,
just should be
and the
let-
custody is only 1 year, my lords. The persons who are selling such drugs, my lord,
Let it come during vacation.
Very well.
lordships.
No, let it come during vacation. No, Mr. Bill. Counter affidavit is not being filed. It be placed on record. I will then place on record.
After 15th, my lord.
But in both
And
cases.
any day after 15th, my lord.
No. No, sir.
My lord,
Then in the
No, sir. Next week.
yes, my lord, next week.
Please tell
All
me.
right.
First week of vacation.
Problem.
You go and argue, sir.
all right.
Whatever would be the fate, we don't know.
That's right.
It's a bail petition, sir.
Correct.
And which cases will be listed? Bail will not be stayed.
No,
Vacation.
I'm not that. But bail of a person, my lord, who is playing with the life of thousands of
Go and
people in the
oppose there.
country, my lord, in the
Go
society.
and oppose. No problem.
Ah. Great.
Please, Your Honor.
Yes, sir.
Yes, my lord. My lordship, on the last date of hearing, my lordship directed to verify the charge sheet has been filed under section 394 or not, my lord. My lord, charge sheet has been filed under section 397. If my lordship may kindly see my counter affidavit, my lord.
What is the allegation? We have seen your counter affidavit, particular para 15.
Yes, my lord. We have,
Anything else? Fine. Now let us understand.
Yes.
What is the deadly weapon recovered from him?
yes, my lord. 390, sir. My lord,
Sir, please, what is the deadly weapon recovered from him?
The motorcycle was recovered, my lord. The motorcycle, my lord.
So how it can be a case of 397 IPC? See the language of 397.
Yes, my lord. May I read, my lord? 397.
Yes, sir.
If at the time of committing robbery or dacoity, the offender uses any deadly weapon or causes grievous hurt.
So what is the deadly weapon recovered and causes a grievous hurt? Please tell us two things.
My lord, it's or causes grievous hurt. They had been, my lord, assaulted, my lord. They had been assaulted. If my lords may kindly see the FIR for a minute, my lord.
What is the grievous hurt, sir?
Yes, ma'am.
See? Anything else you want to say? Please tell us.
No, my lord.
Otherwise, we are granting bail.
Very well.
Okay. Hearing. Do you want to say? Hearing learning from the company. And on the reason of the allegations. The recovery only of motorcycle. From it. So the period of custody, which is about 2 years, I must have. And the trial may take time to conclude. And
Less than 2 years, my lord. 1 year, 10 months, my lord. 4.
1 year, 10 months. And the trial may take time. And the first side as reflected. Or without expressing.
Obliged. Obliged, my lord.
Item 6.
Mr. Hegde is appearing on BC Minds.
Please, my lords. The main conspirator in the criminal case, my lords, has been granted anticipatory bail on the ground that his name does not figure in the FIR. FIR was against unknown persons. It was a very ghastly attempt to murder in the open city, my lords, by unknown persons. FIR was registered. The unknown persons were arrested. Then it was revealed, my lord, this petitioner, through his gunman, hired those unknown persons. Within, my lord, 2 weeks, my lord, interim anticipatory bail is granted on the ground that he was ill, though he was not.
It is a financial trail by this man with the gunman.
No, his gunman, he uses his gunman, has gundas from, my lords, UP, Goa, etc. to eliminate his political rival, my lords. And it comes to light in the course of investigation.
Learned Counsel, what we are asking is, if his gunman do have some connection and payment by the gunman.
Through the gunman. So I should say it's through the gunman.
You can say, sir, please listen once a minute, Senior Counsel.
Please.
Is it any connection that this payment has been repaid by this man, reimbursed by this man?
Please, my lords, there were 2 police constables along with my lords, this petitioner. They have given the statement about the conspiracy. And statements have been recorded, certain statements have been recorded before the magistrate. They have spoken about the conspiracy, my lord.
If you ask this way, we will not accept any contention.
Please, my lords.
The region of his political enemy, which been not denied.
Please.
And now situation is coming, is allegation which is coming, the man was murdered and this one gunman having a connection with the persons who committed an offense made a payment. Now you are connecting through gunman to this man. So we are asking in this situation that payment whatever is made by the gunman, have you connected that this payment has been repaid or reimbursed by this man?
Please, may I answer like this, my lords? Investigation is at law. Investigation is pending. Still at the stage of investigation, my lords. And my lord, that gunman is not yet arrested. He is absconding. There is a statement of 2 other police escorts who were with this petitioner who has spoken about the conspiracy. Police constables are there who were also the gunman to this accused person, accused number 18. Now, my lord, he gets through them he gets executed, my lords. Through them he gets executed. The matter is still at the investigation. Only 2 weeks are over, my lord. By that time, anticipatory bail is granted, my lords. And based on this, now everybody is getting anticipatory bail, my lord.
The petitioner is in jail since 29th January 2025. There is no recovery from the petitioner. The allegation is this, that he is the owner of the vehicle. The only 4 witnesses have been examined out of 22 witnesses. The
Your Lordship, I'm appearing for respondent state.
he was arrested on 29th January 2025.
You are the main person, sir.
Lord, he is the owner of the,
Offences are registered against.
no offense.
You are the main person.
He is the owner of the vehicle, not
You are the main person in this case, sir. 245.105
yes, my lord. The point,
ganja was recovered in the period of custody is 1 year, 3 months only.
1 year and 4
But
4
4 months.
yes, 29th January 25, and out of
2
22
months, sir. It is too early.
1 year and 2 months.
Yes, sir. It is too early. Quantity is 245. Gangale sir.
But my lord, he is the,
Wait for some time more.
after 3 months, my lord, liberty may be granted.
Wait for some time more. You made all attempt to bifurcate, entered into an agreement, gave it, but registered ownership has not been changed.
That is the,
That is right, sir?
yes,
Am I right?
yes. My lord, the 6 months,
How many witnesses are there?
22 witnesses out
How
of
many examined?
4 witnesses.
Let us say within 1 year trial we conclude, otherwise you may.
6 months.
You know, it may not be possibly done. You know this thing very well. Okay. After hearing the comes, at this stage, we are not trying to entertain the present SIP. Based upon the facts of the case, it is directed that the trial be concluded now within a period of 1 year. Otherwise, petitioner would be at liberty to renew the prayer. Post petitioner to cooperate with the
Grateful Williams.
Praise the Lord.
Wait, I can get you.
My lords, item 8, this is an SLP seeking bail. There are 2 aspects, my lords. First is about the inadequacy of material against me. There is inadequate material against me. The second aspect, my lords, everything points out towards the guilt of the husband, and he has been simply let off. He is the person who last visited the deceased. As
He is the person who last.
visited the deceased, my lords, in her premises. She is his wife. The postmortem report shows that the time of death coincides with his last visit. He discovered, my lords,
Time of death.
coincides with his visit, my lords. The time is approximately matching. The second aspect, my lords, that he discovered the deceased in a dead condition on 5th evening, but the FIR is registered 30 hours thereafter. And the FIR is also not lodged by him, it is lodged by mother-in-law, who also speaks about the motive, that despite a divorce proceeding pending against them, he would frequently visit the deceased place, beat her, assault her, etc. Now, in those circumstances, your lordship, he is not even formally arrested. He is simply detained overnight and next morning he is let off.
Certainly he is right. That is right.
Now, my lords, now the material against me. 7th morning, my lords, 6th, 7th, intervening night, he is kept in the police station.
I accept the notice, my lords.
Except notice, counter be filed within 4 weeks. List.
My lords, he has no criminal antecedents. Would your lordship, he has no criminal antecedents. Would your lordship consider releasing him on interim bail?
Be filed within 4 weeks. We are issuing a notice
All right,
reluctantly.
Grateful, my lords.
I'm not understanding. You want the negative points.
No, my lords. I'm grateful for notice, sir.
We can tell you the complete chart we have. You can look into. Complete chart.
Right, my lords,
Okay.
have gone through that. Yes, ma'am.
Counter affidavit file list immediate approval.
Grateful, my lords.
DOP of partial documents. If some help can be possibly, you can take a chance.
My lord, I am for the cavator respondent number 1.
Yes. Yes, Mr. What is wrong in this?
Lordship, I appeal for the petitioner.
Yes,
Yes,
that proceeding is
back
also.
into this arbitration. Let me complete, Mr. Margaret.
Please.
Yes,
Uh,
Mr. Khanna.
Yes, the petitioner is being dragged into this arbitration proceeding based on a MOU where I'm not even a signatory, I'm not even a party. For that, one has to refer to section 2H of the Arbitration Act, which says that it has to be a party.
In this company.
I had resigned from this company in 2018. This MOU is of 3 years later. There are issues which have to be raised.
Uday. Yes, Mr. Uday.
Yes, Lordship, my entire case is on the premise that the transaction has taken place between the petitioner and respondent number 2 on behalf of the company. I hold this particular piece of land which could not have been arbitrated upon because I have not given my consent. What the Honorable High Court has done is they have looked into Cox and Kings and says that this is a complex issue, so they do not go into my role in this particular matter. Now, when one has to look into this, we have to look at section 2H, read with section 7, which talks about party. I cannot have been a party because I have not given my consent to this arbitration. I have not given my consent to this MOU.
You
The
were
second
party to
aspect,
the agreement or not? Please tell us.
Lordship, please.
You signed the agreement or not?
I did not sign this particular MOU. I did not sign this particular MOU.
And all objections have been left open for you. You go and raise all these objections. This cannot
In
be.
section 16, if your Lordship gives me the liberty, I will raise these objections in section 16, Lordship. But however, there are 2-3 aspects which one has to look into. This land has been attached by ED. So once the statutory body has looked into it, it's a right and rem. It cannot have been decided in arbitration.
The stage of arbitration. Sorry.
Nothing has been done and he has, my lord, he has participated in the proceedings. He is participating in the proceedings. He has raised this preliminary objection.
The petitioner is struggling. Why you are? You want to create more problems? Sorry.
Why should I?
Sorry, sir.
May I please minutes? May I please minutes? Minutes. Unfortunately, minutes, the Honorable Division Bench has failed to consider the fact that none of the documents were proved during the trial before the learned CGIT minutes. All those documents were discarded. No original documents were produced before the CGIT minutes, and adverse inference was drawn for not production of all the documents. But now, your lordships may kindly note only 2 dates minutes. But I filed a writ in January of 1993 alleging that I have been employed through different contractors and I may be regularized. I'm so deeply obliged.
No, please, my lords. My lords, Honorable High Court has gone on a different tangent, my lords.
Issue notice of delay as well as.
Stay may be granted, my lords, other would be. My lords, my lords, it's
This can be granted.
it's in teeth of my lords.
You have to pay, no, nothing, no teeth, sir. If you want to ask, only one clarification is required, therefore we are asking, nothing more in this case, much more. One clarification with respect to that situation, regularization or period, nothing. Here it was a 4 year only.
Yes, my lords.
So just you can't say much more, sir. Very little scope in this. We are telling you very frankly. We have dealt with all cases.
My lords, I've heard it for good 3-4 days.
That to what extent it can be done.
So,
If you want
Rakesh,
to get more benefit, go and we are giving a chance to you.
obliged, my lord.
Other than
Obliged.
that, we can clarify this and finish it. This was
No, my lord. I'll leave it to that, my lords. I'd rather have this, my lord.
Pass 2 judgments on this same.
I'll have this, my lords. I'll have this, my lords. Obliged, my lord. Deeply obliged.
If we have passed, we would have seen everything.
My lords.
We know this thing. Anyway, thank you. So much.
Because in item 12, I seek a pass-over in the matter. There's a cross appeal as well.
Only that the home bias may not be in a position to get convict. So you have come now.
No, my lords. There is merits. I'm being led by a senior. May I request a pass-over, please? I'm grateful.
Item 13.
May it please, your lordship. No, only a small issue, ma'am. No, your lordship decided the Suraj Mani batch of matters, Lord, and in that, Lord, your lordship categorically said, Lord, the issue was also framed that only work charge status. Well, we are not shying away from giving work charge status. We are giving it to everybody. But the executing court, Lord, in an execution petition says, no, you regularize them also. Lord, your lordship, kindly have page 288.
My lords, I'm here on GOVT, my lords. My lords, that is incorrect, my lords. My lords may kindly see. My lords had passed Suraj Mani judgment on the base. My lords have already dismissed a similar matter, my lords, where they have relied upon, my lords. Their review has been dismissed against, my lords. Kindly see, my lords. My lords may kindly see the grounds in the review, my lords. Thereafter, my lords, that SLP of Gopal Singh also has been dismissed by this court, my lords. That clarification is gone, my lords. My lord, Suraj Mani was given specifically on the basis of Moolchand Upadhyay, my lord, Moolraj Upadhyay, my lords. Moolraj Upadhyay said first work charge status, my lords, and then regular rights. My lords, kindly see at page 289. My lords, may please see page 289, my lords. The review against this order of Suraj Mani in this particular case has been dismissed, my lords. And this is an execution.
So let us understand this is an execution.
Yes, my lords.
Main direction in this case.
288, page 288 of the SLP paperbook, Lord.
I'm taking, my lords, page 289, my lords.
Now I'll come to that also. 288, your lordship. Paragraph 3.
Paragraph
3. 288. Now may I just read it? Now they say the short point that arises for our consideration in these appeals is whether a daily wager is liable to be conferred work charge status after completion of 8 years of service. In other words, whether the benefit of work charge status could be given to a work charged employee after completion of 8 years of service. And this your lordship decided now. We are not shying away. We are saying we'll give them work charge status now to everybody. Now,
sir, please.
I'm good.
They have
I'm good.
taken up the matter.
I'm
You
sorry.
want to say.
Yeah,
Taken up the matter.
No.
And then on half day you left it.
No.
Point was this.
Yes.
So we do not want to say.
No, I'm sorry.
We are asking what are the directions.
Your lordship have
please
page
give us the direction.
293, paragraph 8.
Yes.
Milos, may I read, Milos?
Yes, please.
Now it says, however, in order to ally the apprehension of the state as expressed thereunder and to safeguard the interest of the state which otherwise would have burdened the exchequer with extra benefits being conferred on the employees who had not been regularly appointed, this court has, as a succor to the state, restricted the claim, or in other words, modified the order of the tribunal as affirmed by the High Court by arriving at the conclusion that the petitioner appellants therein would be entitled to notional benefits of the order passed by the tribunal and accordingly disposed of the said appeal. It would not be out of context to refer at this juncture itself that the state, in its wisdom, having felt that the subsequent schemes having been formulated and implemented would alter the situation and therefore order dated so and so, your lordship will rely on these previous judgments, then I'll skip through this, paragraph 10, then your lordship will have, page 295, for the cumulative reasons AFO stated, we are of the considered view that the dicta laid down by this court white order dated 22nd of July 2019 and Ashwini Kumar Supra case, which is based on the judgment of Mool Raj Upadhyay, holds the field and would also be applicable to the respondents herein who had approached the tribunal or the High Court seeking similar relief. As such, the respondents shall be entitled to grant a work charge status from the date of completion of 8 years of service. However, we hold that the relief in the present appeals will be limited to notional benefits as explained in paragraph 3 and 4 or Ashwini Kumar's case Supra, so and so, and the present appeals stand disposed of accordingly with no order to cause. We also make it explicitly clear that the state in its endeavor for implementing these orders of the tribunal, High Court or this court, if having paid the amount in excess, would be at liberty to take such steps as it deems fit without insisting for one-time recovery.
My lords, may kindly see page 2. My lords, please see it too. My lords, please see. Yes, my lords. My lords, kindly see this. That is because, my lords, it's a, my lords, for last, yes. Kindly see at page 289, my lords. That is the Mool Raj Upadhyay scheme, my lords.
Yes.
What my learned friend has argued is in para 4, my lords, taking into consideration the facts and circumstances of the case, he modified the said scheme by substituting paragraph 1 to 4 of the same by following paragraph. Master role workers, whether skilled or unskilled, who have completed 10 years or more of continuous service with a minimum of 240 days in a calendar year on so and so, shall be appointed as work charge employees with effect from 194, shall be put in time scale of pay scale in the corresponding lowest grade in the government. Now, my lords, please come to para 4 on the next page at 290. Daily wage muster roll workers shall be regularized in a phased manner on the basis of seniority, cum suitability, including physical fitness. On regularization, they shall be put in the minimum of time scale payable to the corresponding lowest grade applicable to the government and would be entitled to all the other benefits available to regular government servants of the corresponding grade. Now, in the light of this, my lords, please read my lords' direction at page 295, which my learned friend just read, my lords. In Ashwini Kumar, only modification was, my lords, that they had given notional benefits. In these cases, my lords, the High Court has given benefits for last 3 years. That, my lords, have taken away. Please see at page 295, para 10, my lords. For the cumulative reasons appropriated, we are of the considered view that the dicta laid down by this court white order dated so and so in Ashwini Kumar case, which is based on the judgment of Mool Raj Upadhyay, holds the field and would also be applicable to the respondents herein who had approached the tribunal or High Court with seeking similar relief, my lords. Now, kindly see my relief which I had sought, my lords. My lords, may please come to page 174. Nothing more has been modified, my lords. And my lords, what is the argument before the High Court? They say this was wrongly tagged with the Suraj Mani case, my lords.
474.
174, my lords. I'm sorry, my lords, there's some mistake. I'm sorry, my lords, there is some mistake by my pagination, my lords. 47, where my prayers have been reproduced.
Yes.
And one which were allowed by the learned single judge at 148, my lords.
Yes.
Issue a writ on mandamus or other appropriate relief, direction, order or direction directing respondents to grant work charge status after completion of 8 years of regular daily wage with effect from so and so, and regularize the services of petitioners with all consequential benefits, my lords. This is what my lords have done in Suraj Mani's case, my lords. Relying upon Mool Raj Upadhyay, my lords have said only what we are modifying is the notional aspect, benefit aspect, my lords, that we will get only notional benefits, my lords. Nothing more has been done, my lords. And my lords, this matter went, the Suraj Mani, my lords, in this particular case of Santaram, my lords, the state filed a review. Review has been dismissed, my lords. Kindly see the grounds of review, my lords, where they rely upon Gopal Singh, my lords. That SLP also has been dismissed by this court on February 26, my lords. Very recently, my lords. I'll show the judgment. My lords, may kindly see the grounds of review, my lords. They have been reproduced in the impugned order itself, my lords. Kindly see at page 7, my lords. And page 8. For that, the order dated 16/5, this honorable court in special leave petition, diary number so-and-so, entitled State of... My lords, page 8 of the impugned order, my lords, where the grounds of review has been reproduced, my lords.
Yeah.
At C, my lords. And my lords, one more thing. (525), this honorable court petition number so and so, entitled State of Himachal Pradesh versus so and so, has issued notice. It is most respectfully submitted that the case of Gopal Singh is on parity with the present case of the petitioner state. Now, my lords will have this order, my lords, where my lords.
Yes, ma'am. Now,
One more thing, my lords.
No, what?
One last thing, my lords, then you may start. And it is very unfortunate, my lords. My lords have seen that mentioning also, where they said at every stage what the state is doing is we are taking an excuse either by they say that we are filing a review, or they are making a statement that we will comply with the order.
Comply.
In this particular matter, my lords, in execution petition, my lords, on 11/3/26, my lords, if I just can read, Learned Advocate General on instruction submits that steps have been taken for implementation of judgment so as to regularize the petitioner in the project as a matter personal to them. On instructions, my lords, the Advocate General makes a statement that he is complying with, and he takes time, my lords, and on 30th March, they file this petition here. My lords, this can't be done, my lords. I've worked for 30 years or more, my lords.
Yes.
now, may I just say this? Now, my learned friend was also there when these Suraj Mani matters were heard. Now, in those batch of cases, your lordship restricted it only to virtual status. Now, they should either say, no
reason to do.
No, your lordship, kindly bear with me for a minute. No, kindly bear with me. No, I am only saying, Lord, since they did not agitate it there, Lord. In Suraj Mani, they accepted Suraj Mani. We also accepted.
Go like this, sir.
No, your lordship, kindly see, Lord, what was the main issue framed in Suraj Mani? No, your lordship, kindly, no, 1 minute, your lordship, bear with me. No, your lordship, this will create a huge financial implication for the state, because it was never agitated. The regularization was never a part of Suraj Mani.
Please.
I'm grateful.
May I request my lords to take the file of 14.1 first? Because that's the petition under section 11. My lords, this is squarely covered by my lord's judgment of Maharashtra state.
Seen the terms of the agreement?
Yes.
Was it based on the LOI and FCC?
There were two aspects.
You have subsequently entered into an agreement where you have specified that there is an agreement.
My lords, kindly have.
Seen that.
No, my lords, I clarify.
Madam, I am aware.
My lords, kindly have an extra P1.
But we have written now.
That is why, my lords, I'm relying on that, and I say
We know that you will catch hold us.
No, that's not, my lords. It is in my favor, my lords. I'm citing that.
Where is that page
My lords,
number?
kindly have P1. My lords, kindly have.
Page 171 of the.
One
My lords, I want to first come to the NIT. My lords, I am NBCC. I am the project management consultant of NTPC.
I have seen both compared with that judgment and this also.
Well, it's just 14.1. Well, it's 14.1 in the pages.
I just look into.
Yes.
You are arguing. We have to look into.
Yes.
Page number.
Well, let's kindly have page number 38, which is the 38 in 14.1.
38.
Now, clause 1, my lords. This is the NBCC's my lords, NIT.
Yes.
Kindly see.
We are.
Yes. One says NBCC Limited invites sealed bids for construction so and so. All terms and conditions as contained in the tender issued by NTPC to NBCC shall apply. Mutatis mutandis, except where they have been expressly modified. Now please come to clause 5
of, that is at page 52. These are the set of contract documents. My lords are there with me?
Yes, sir.
Page 52.
Yes.
The following documents,
Yes, sir.
NBC's SCC, yes. NBC's documents are NIT, instruction to tenderers, then NBCC's SCC, then minutes, and then the second set of documents are GCC, SCC. These are all NTPC to NBCC. Now kindly come to page 54, which is the order of precedence of the documents, how the documents will be read. Kindly have at 3, NBCC's NIT, ITT and special conditions of contract. They have to be read first. Now come to the jurisdiction part, which is most important, which is clause 20 at page 61. May I read, my lords?
Yes.
It says the agreement shall be executed at New Delhi on non-judicial stamp paper purchased in Delhi, and the courts in Delhi, New Delhi alone will have the jurisdiction to deal with the matters arising therefrom to the exclusion of all other courts. So this is what is the NBCC's document, my lords, which is relevant. This is also a two contract, my lords, tender, because the first is the NTPC and NBCC, the second is the NBCC with the present respondent. Now, my lords, arbitration clause is P2, which is the NTPC's GCC. Yes, I know, I've already said.
Yes.
Now, arbitration clause, which my learned friend is relying upon, is annexure P2, which is the general conditions of contract for civil works. It is a general, my lords, for all civil works of NTPC, and there it is clause 56. I would want to read that also in toto, because this is also, my lords, for the operation of law, this can't be now followed. Why? I'll just read that, my lords. Kindly come to 8 lines from the top. May I read, my lords?
Yes. Page number?
Page number is, my lords, 272. I'll read the entire clause. Arbitration. Except where otherwise provided for in the contract, all questions and disputes relating to the meaning, etc., designs, drawing, materials used on the work, or as to any other question, right, matter, or thing whatsoever in any way arising of or relating to the contract, design drawings, specifications, estimates, instructions, orders, or these conditions of otherwise concerning the works or the execution, failure to execute the same from arising during the progress of the work or after the completion or abandonment thereof shall be referred to the sole arbitration of the General Manager of NTPC Limited, formerly National Thermal Power Corporation Limited, and if the General Manager is unable or unwilling to act, to the sole arbitration of some other person appointed by the Chairman and Managing Director NTPC Limited, willing to act as such the arbitrator. There will be no objection if the arbitrator so appointed is an employee of NTPC Limited and that he had to deal with the matters to which the contract relates, and that in the course of his duties as such, he had expressed views on all or any of the
What
matters
do you
in
want to say? This is a clause of arbitration. What do you want to say?
I say that this is not applicable because what will be applicable with the will be the NIT, which is NBCC, which is my contract with the respondent. This contract, this arbitration clause is there in the general conditions of contract of NTPC. I am the project management consultant of NTPC. So NTPC gave the work to me. I have entered into agreement with the respondent, and in my agreement there is no arbitration clause. 56 is in the GCC of my where I have entered into contract NTPC.
Which, suppose we go by the NIT.
My lords.
NIT issued by?
NIT is by me, NBCC.
Alright, you issued an NIT.
Yes.
You gave a contract to
The respondent.
respondent.
Yes.
How NTPC comes into the picture?
Because that entire work is from the NTPC. I am the project management consultant of NTPC. They have the general conditions of contract. That is for me. Their arbitration clause is there. I have entered into contract with NTPC. Now, when I have
Who is going to be affected by this?
My lords, the NIT says it has to be the courts in Delhi which will have jurisdiction. The NIT does not have any arbitration
We are
clause.
asking of 2 points. First, we are asking of it's a matter of 14. One is a matter of appointment of the
11, yes,
Yeah.
appointment of the arbitrator.
Section 11. We have to look into the basic contract.
Basic contract.
So basic contract was
let's kindly have the NIT, and then the contract was, which was entered was the agreement at R5, 14/9/2007. And there is no incorporation. It is a general reference. In the contract, my lords, there is no incorporation, which is the bedrock of my lord's decision.
Spirit of that judgment which we delivered.
Yes.
What we delivered is
My lords, 7/5 says,
NIT flows, the conditions, impact thereof has to be looked into
Yes.
because we distinguish the judgment of justice Surikal.
yes,
Alright?
I know.
So we taken this from that
Yes.
and then we have to go to this extent.
I bow
And
down.
That situation,
I bow
we
down.
say no, there is no, nothing is there.
Because, my lords, very categorically,
That day you can't take advantage of that.
my lords, what I'm showing is that there is no arbitration clause between both of us. The agreements does not provide for it. Then also, my lords, there is a general reference.
Thank you.
Kindly have 7/5 for a
We have
moment.
heard you, what
My lords,
you,
I
what
want
we
to-
are clarifying.
I want to show.
Not to say much more.
Well, it's clause 10 says the order of precedence of documents in which the NIT comes
No
first.
reason to interfere.
I'm so glad.
And the subsequent is of the change of the arbitrator. 14 is the change of the
My lords,
arbitrator.
this issue can't be arbitrated because there is no arbitration agreement, my lords. That is my precise submission.
We see no reason to interfere. Madam.
My lords, can I only show the
Madam ji,
agreement between,
I am aware of that.
only one, my lords, I have,
Certain judgment, I know where is the
my
flaw
lords,
is lying in the.
my lords, the facts of this case, I just want to show
Yes,
one
please.
document.
Let's-
Lords, can I just show one
Next
document?
case,
I'm so glad.
Well, it's then, I may be allowed, I may be allowed to raise this issue.
objections. Fine.
I have an objection.
Arbitrator has already given them liberty. They are supposed to file the section 16.
Certainly, this is always a liberty.
Of course, great.
Well, it's
Always,
just,
there is always a liberty with them. So this cannot be at this stage cross.
No, of course not. Manoj. That's exactly
Yeah,
that's
because
it.
this-
That's
yes,
exactly
we are
what I
aware, but just because we have come here in SLP, Malats, I'm just taking that.
See no reason to interfere. However, the legal objections are available to the petition. Maybe
Malats,
permitted to be raised before the argument. Anything else?
Malats, there was one document
half.
I want, no, Malats, I thought, Malats, this requires little attention. If Malats would only see the annexure
If I
5,
should not have seen that judgment thoroughly,
Malats have,
yesterday, the first instance night, I did it. Then I asked to my colleague, that law clerk, please come with that judgment, see that nicety of both. I put it with a lens.
Malats, there can't be any doubt that Malats goes through each and every document.
Thank you.
I'm so blessed.
I'm grateful.
I don't actually see that there has been, the Delhi High Court has given a
What is this document, sir?
let me explain.
We can understand
Because-
that you taken this document is produced by the owner in the police station. You taken a copy thereof, you rely upon that document.
Yes, Milord.
Fine. So now on the basis of the same, if PN recovery is directed, there cannot be any problem to you. And what the High Court says is the document may produced by the owner, but it's a forced document. Then how you can claim on the basis of the same insurance company? These are two situations.
There are two situations. Milord, I've in fact submitted a judgment in the ninth, Milords, Shobhit Singh, where Honorable Justice Mirza of Delhi High Court has given suggestions, Milords, where with the assistance of the senior counsel, Mr. Gopal Subramanian, senior counsel. But there it was said that in that case, Milords, paragraph 7.18, Milords, that Milords, at the threshold in the CGM score, the police should have confiscated and sold off the vehicle and given the money to the person who has died or injured, Milords. And here there was a folly before the CGM court, Milords, that everything was done and they showed and they made an inquiry before the insurance company.
How this is relevant? Can I put in different way, sir?
No, Milords, I'm submitting, that's a suggestion given in the,
Submitting suggestions, keep suggestions aside.
that judge.
Please listen for a minute. MACT relying upon the fact that a document which is produced by the claimant is a document seized by the police from the owner. On the basis of the same, the vehicle which was involved in commission of the offence has been released in favor of the owner. That was the insurance policy. They say liability of insurance as well as so and so, pay and recover. When it came to the High Court said that the insurance company has taken a plea that this vehicle is not at all insured and this is a forged document produced by him. And on the basis of the same, this plea was accepted. Suppose a document on the basis of which the claim is surviving, in which a finding is recorded, if it is found that it should be forged, how you can rely upon the tradition, sir?
May I submit, my lords? May I submit, my lords, on this? Because what happened was that the truck was seized and it was lying in the police station. It was lying in the police station. Before the CGM, there was an inquiry held. And the police officer had to, under the investigation or inquiry, whatever, he had to only go to the insurance company which was in the same town. He goes there, finds that the insurance certificate was right. And my lord, one thing has also come here.
Document we have filed here, inquiry held and everything is done.
Oh, that was there in the statement, lordship. Can I take to page 29, my lord?
Document.
Page 29, my lord, they have said everything. Trial court has decided in my favor. Lordship, what has happened, lordship would see the...
Things are in the manner in which you are arguing trial court decided in my favor. We have not seen those things, sir.
But lordship wants to... Trial court, page 29, my lord. See.
Court decided what the High Court said. Which is a judgment here. The court said the document initially is itself is a forged document.
But with due respect.
It will be given to you.
Lordship, with due respect, my lord.
We are asking you, you are saying some inquiry was conducted and said it is not a forged document. Where is that document before us?
That I'll file, my lord. That I'll file, my lord. I'll file.
I'm not saying. I guess that whatever you will say, we'll accept it.
No. I'm only saying, my lord, that
you make out the case that the finding which is recorded by the High Court, if we look into these documents, cannot be sustained. We can understand.
Yes, my lord, I'll do that, my lord. And second thing is, my lord, he had another 3 trucks. He had 3 trucks. The High Court has indicated, not in this truck.
Counsel for the petitioner prays for him done. We are not interested to dismiss everything.
My lord.
We are interested, you have some claim, only then can be.
My lord.
Otherwise, you cannot take with us.
My lord.
After hearing learned counsel for the petition, learned counsel for the petitioner prays for him done. 4 weeks time to file with 11 documents regarding holding an inquiry by the investigating officer on the point of the insurance policy.
My lord.
List of those 11 documents be produced with list thereafter.
BC by line journey through BC, my lord. देख लो BC पे कोई है?
Yes, sir.
My colleague is joining through BC, my lord. This item 16.
Yes, sir.
My lord, am I visible?
Not visual.
Okay. My lords, only 2 seconds, not more than that, my lords. I rest my case. I board on to this honorable bench judgment dated 24th April 2026, case of Vinay Deshmukh versus Natwar Lal, in which this honorable court has said that the honorable High Court cannot cross or cannot rely on material evidence in 227. In the present case, the petitioner has taken off the records which were not there in the trial court, and based upon this honorable court has passed a judgment totally brushing aside the reliance of Rajneesh versus Neha. What all precedent this honorable apex court has laid, that not even a single word in the judgment of High Court says that based upon assets and liabilities affidavit of both parties, the honorable High Court comes to this figure. The trial court has rejected the maintenance because the documents were not there on record. The trial court has also said the documents that relied by the petitioner before this honorable court were there on record, and none of these documents are refused or denied by the respondent in the trial court. Now, the honorable High Court relies upon all these documents or YouTube, specifically a YouTube channel. My lords, the apex court has relied that the assets and liabilities should be referred for the maintenance, and the High Court entirely relies upon the media presence. My lord, in the word of
I can. It was tried by a retired judge of the High Court. It didn't work out. So it didn't work out. I have no difficulty in trying at all. But I think plus 2018 to 2026, 8 years. Have you filed divorce? Is there any divorce petition, etc.?
Yes, it's pending. It's fine.
By the other side. So because I think it was tried, it was not worked out. For 8 years now, Milos, this is.
How much are you depositing some amount? Then we can thought of something. Otherwise, we will not.
I've been depositing, my lords. Even on last Monday, I have deposited 5 lakhs, my lords. I am under heavy areas. I am not able to sustain this amount. 5 lakhs I have deposited on Monday. Last Monday I have already deposited.
What is the total sum is coming? Suppose we calculate on the basis of 3 year, 18 to 21, 21 to 24, then thereafter 2075. So suppose we thought of it that yes, you really want to bona fide man, you want to do something.
I agree.
Tell us how much amount comes and how much you have deposited. Please tell this thing.
Roughly or
Can I give the figures?
Yes.
Page number 75 to 76, the figures are there in the SLP. Page number 75, 76. The figures are already there.
How much it is coming?
Can I indicate the
16 odd lakhs. Apart from this, 5 lakhs I have paid on 18th of May. I have already paid 5 lakhs. Apart from this figure.
This you deposited, what we are asking learned counsel. Suppose we apply the judgment as directed by the High Court.
Yes.
If we apply, then what would be the amount come?
It is 74 odd lakhs. 74 odd lakhs.
He is saying 79 lakhs. How much out of that? Suppose you deposited this much amount which you are offering, which you are saying, this is of 16 lakhs approximately.
Yes, actually 12 years because 2 checks bounced. So 12 lakh 20,000 is what I got in 8 years, Milos.
My lords, I was in jail. My lords, I was in jail and they were already, lockdown was there. I was in jail. That's why I was not able to pay, my lords.
Milos, Lordship will ask him which offense he was in jail, not at my hands.
That's not a problem. See, offense, it's not proved. When it will get proved, then I'll say. I wholly have reliance on the honorable judiciary.
Do you listen for a minute, sir?
Yes.
Are you interested to deposit half of the amount?
Yes.
Which
My
is
lords,
this time within a period of 8 weeks?
My lords, it's beyond my capacity. I'll deposit 5 lakhs, my lords. 5 lakhs I concede, I'll deposit 5 lakhs. My lords,
No interference.
my lords, please, this is the last court, my lords, with folded hands I'm coming before this honorable court. My lords,
Saying to you, sir, we can also hold our hands to you.
I know. That's why I have totally relied. My lords may raise some amount beyond 5 lakhs. I'll pay something, my lords. Give me
Interested to deposit half of the amount within 8 weeks.
my lord. Half of the amount will be too much, my lord. At least give me time. I'll pay 10 lakhs. 10 lakhs I'll pay, my lords.
Nothing can be done, sir. Nothing can be done.
My lord, at least consider some amount. So, my lords,
Why, sir?
50% amount is too much beyond my limit. That's what I'm saying.
Yes, please.
But my lords, I'll reasonably try to deposit 25 lakhs. 25 lakhs I'll try to deposit, my lords. 25 lakhs is a reasonable amount for them also. We are squarely reaching there.
In addition to whatever he has deposited, 25 he will deposit.
20.
I take it, Milos. I don't even need instructions. I'll take it as call at my level.
Yes. Okay. Learned counsel appearing on behalf of the petitioner. After arguing for some time submits that the petitioner is ready to deposit 25 lakhs.
He can pay.
The amount already deposited. Already paid.
He can pay me, Milos. There's no dispute on this.
Let them come deposit.
No, Milos, no difficulty. Whatever your lordship says, I have absolutely no difficulty.
Deposit with the registry of this court, Milos.
Sir, we are saying.
Yes, Milos. No difficulty.
25 lakhs within a period of 8 weeks.
Correct.
We take this as a statement on record.
Milos.
Yes.
Full stop. Issue notice. Returnable in 8 weeks. In the meantime, for the remaining amount, subject to payment of the regular amount of maintenance.
Milos.
The That's good. So the application of the impugned award shall remain state.
Right. And if he doesn't deposit, Manoj, then Lordship will just make an order so that there's pressure on him. That's all.
Full stop. In case the amount as offered is not deposited, this court may pass appropriate orders on the next day.
Grateful.
arrest warrant they have issued
Yes. Execution we have said state.
The remaining amount, it will remain state subject to deposit of current. Great.
I love. So being led by learned senior counsel Mr. Bajantri appearing through VC Malay.
I am appearing for the petitioner, my lord. Yes. Matter relates to change of cadre from the post of assistant executive engineer to that of assistant director town planning. Rules of recruitment are bound. It is at page number 61, my lord. Lord, I have prayed for interim order. I had the benefit of interim order from the interim order to continue in the post of assistant executive engineer. At present, with respect to posting, the status quo as it exists today shall be maintained till next date. Please, Lord.
May I request for a passover, Lords? The Lordship should be pleased to grant a passover.
In 8 weeks,
We are in KVA, Lord.
the status quo as it exists today shall be maintained by the department.
We are accepting notice, Lord, in the KVA.
Who are for?
I'm for the R1.
Please sit, sir, in this case, you have to sit and materialize the things. Otherwise, there is no purpose.
Lord, this is a concurrent finding for the joint
But we
member.
have understand, sir, even then we are issuing a notice, something we would have find.
Yes. I will file reply.
Better is sit there, and so far as that share of these persons are concerned, you find out, you have some deliberations, make it some deliberations, take some amount and give it and finish it. Unnecessarily fighting for the things.
I'm accepting notice, Lord, on behalf of our. My Lord may have any returnable date.
With that instructions on the next day, go for.
Yes. Yes.
In the meantime, status quo as it exists today shall be maintained. Number, customer number?
R1.
R1 only, remaining corresponding content. What's the rest?
Yes, sir. Any date not returnable. Great. Please, Lordship.
Lordship, leave to defend application was allowed by the learned rent controller, which has been upset by the impugned judgment, Your Lordship.
Yes.
When there is, admittedly, Your Lordship, there is a finding, categorical finding in my favor in the impugned judgment. Kindly have, Your Lordship, page number 6, para 16.
Impact of, what would be the impact of that suit? Nothing.
No, Lordship, that suit is still pending in the sense, Your Lordship, first appeal is pending.
Make any difference if you succeed there in my own judgment with Justice Indira Banerjee. You can look into.
No, in fact,
Delhi.
Your Lordship may kindly see, there is an agreement to sell in my favor in 1990. There is an agreement to sell in his favor. It is not that he has got a sale deed.
Different issue here. It is nothing can be done here.
No, Lordship may kindly have para 16 of the impugned judgment for a minute.
Nothing can be done, sir. Here.
Lordship, one line only, Lordship, I'll read. Para 16 of the impugned judgment, page number 6, Lordship.
Yes.
In view thereof, there is no gainsaying that landlord-tenant relationship between the parties are not established. So once, Your Lordship, there is no landlord-tenant relationship, under Delhi Rent Control Act, Your Lordship, the petition is not maintainable. Therefore, on this ground only, Your Lordship, the learned rent controller granted me leave to defend. It is not that I'm willing to go before the learned rent controller and contest the petition, establishing my title, Your Lordship. And it is not that I am agreeing to his landlordship, Your Lordship. Kindly see, 10th June 1996, Your Lordship, there is an agreement to sell in my favor. Lordship, in the meanwhile, execution be stayed, Your Lordship.
In the meantime, status quo as it exists today shall
Deep
be
level.
maintained. Gate लगा दीजिए.
Deep level.
Gate लगा. Item 20.
Please, Lordship, in this case, the plaintiff claiming herself to be daughter of two brothers, that is Rama and Bulau. She has filed a suit before the trial court saying that she is the daughter of the Rama, and in the plaint she is stated to be the daughter of Bulau. And on the basis of the contradictory finding, the trial court had
You don't want to give anything to your sister.
yes, she is not my sister.
You can say so, sir.
Actually, she has
You
not.
can say so.
Actually, Lordship, she has not proved at all.
Say so, sir.
She is totally outsider. There is no difficulty.
Go outsider, no, sir.
There is no difficulty.
It's a very peculiar case. In this peculiarity, if you see, Phool Kumar is first married with the Rama.
Yes.
Alright, this Rama, then Rama died. Then this Phool Kumar married with Bhawal.
No, my marriage is not proved. Even Phool Kumar, see,
Who are you, sir? By the way,
No,
you are legitimate.
I am the son of Bulau, second brother. I am the son of the Bulau Lordship.
You see,
I am the son of the Bulau.
now they have Bhawal and this Rama. In fact, it is being said this Rama and Phool Kumar was having son. So this is a peculiar case.
Phool Kumar, the marriage of the Phool Kumar with
Who are you,
Bulau.
sir? Then, if Phool Kumar is not there, who are you? Marriage illegitimate.
I am the son of the second. I am the son of the Bulau.
Has been given to you. This is enough.
No, Lordship, there is no difficulty if she is my sister, Lordship. She is totally outsider. May kindly consider. There is contradictory statement made by the plaintiff, Lordship.
Thank you very much.
The trial court has dismissed this suit, Lordship.
Sir, thank you.
Lordship,
Thank you, please, sir.
much obliged. The Lordship, there is some delay of
Thank you, please, sir.
There is some delay, Lordship. I am requesting to condone the delay. 65 days.
Delay can do.
Much obliged.
Happy. Half succeeded. Huh? Thank you.
Yes. My lord,
Why you cannot go in a division bench, sir? Why you cannot go in a writ appeal before High Court?
my lord,
Kindly see page number 1 is the petition and article 226 of the Constitution of India. Go in High Court.
please, my lord, I will kindly
Learned counsel seeks permission to withdraw this SLP with liberty to file the writ appeal before the High Court. Dismiss as withdrawn.
I'm written.
22.
Lordship, and for the petitioner, Your Lordship, the respondent in this matter has been filing several IAs when the matter has been reserved for judgment, Your Lordship. He has filed IA for recall, IA for reopen of the case.
Even a civil case. Well, we'll take
Hello.
this. In the meantime, further proceeding case number so and so. Can you give a case number and court number?
Yes, Your Lordship.
So and so.
Stay.
Stay. Till next day. Wait लगाना सो.
Your Lordship may permit Dusty also.
In addition, 10 day permit.
Obliged, Your Lordship.
23 days they let out.
My lords. That's clearly called by your own judgment, my lords, Radheshing, my lords. And here, my lords, is clearly a civil suit.
Mistakes, sir.
No, I'm not saying so that.
If you
Lord,
show
kindly
our
see the
mistake-
kindly see this.
If you show our mistakes, then we can.
I'm just citing one judgment of
If
your.
we improve, then you will understand. what-
No, my lords,
Huh?
actually, my lords, you are,
That would be-
you remember everything very clearly. That's why I just said that judgment. And my lords, kindly see the sale deed, my lords. In the sale deed, there is no plot number is mentioned. The only, kindly see page number 26, my lords. And see,
Take all these defenses now at the appropriate stage.
my lords, actually what happened here, my lords, there is a land, my lord, open land. Now he wanted some different plot. Otherwise, give me the money. And he filed this criminal case as well as filed a recovery of the suit also. The suit is pending. Kindly see that.
You are pointing out a finger on others. They are pointing out a.
That is a civil dispute, my lord.
Line sit there.
And 2016 to 22, he is.
No, it is not a-
My lords, here is
Not
that.
civil, sir.
My lords, kindly, one minute, my lords. Two at a time, two litigation
It is
cannot
not- it is
be
not
done. He
civil.
filed a recovery suit as well as, kindly see the page number 29 for a moment, my lords.
That is entirely different.
And land is there, and he is in position, my lords, he wants a different
Sir.
land. My lords, kindly appreciate it.
Nothing is
Page,
there.
my lords, criminal as well as civil, my lords,
Right, sir, thank you very much.
29 page number, kindly see the
Thank you very
29
much,
page number.
sir. Thank you. You go already. देखिए, we are not inclined to interfere. However, the dismissal of this SLP could not debar the petitioner to take their defense at appropriate stage during time. Thank you.
My lord, to civil
Thank you,
and
sir. You must be happy by this. Otherwise, 25. 25. Are you ready to deposit this amount first?
Yes, madam. I will deposit.
Okay, issue notice. Subject to deposit of the entire amount within the period of 8 weeks from today.
4 weeks, ma'am.
8 weeks from today. What more you want, sir? Without even opening a word. The execution of the improved judgment shall remain still. Full stop. The amount for deposit पहले में कुछ challenge किया था ना, वो भी deposit करके short term इसमें भी.
Before the trial court, ma'am? Before the trial court, ma'am?
Yeah, with the registry of this court.
Obliged.
26. Passport. 27.
I should totally ignore the specific provision that the offences are compounded. Well, can we see the so, well, if your lordship is issuing regarding this, then only to number
That
one.
these things may come, then thereafter when it will be dealt with, then some issues may come.
Lordship may can be, well, stay in the meanwhile because
Stay.
the High Court had directed that all those FIR which are registered in the past, they should also, investigation should be closed regarding that, they should be sent back.
Sir, can we do anything today at this stage without the other side? Notice on,
They are not concerned with it. It's
notice on stay also.
permission to file SLP and the deliver
Permission,
and the deliver.
permission.
Your lordship may give it fixed date, because of the reason that otherwise.
Sir, it will come.
So it will be.
Midday this honorable. And it's even if the allegations are taken on face value, it would at max be the violation or infringement of patent. It, in my humble submission, would not be forgery or cheating as has been alleged, my lords, or that of copyright. My lords, if my lords may kindly have.
So have the same option, go and raise all objections, whatever is available to you, Mr. Upadhyay.
My lords may kindly have 39 for a moment, the FIR, 39 for a moment. My lords, in allegation itself, it says, for a long time, information was being received that in Umaria, Dongria industrial area, there is a PVC pipe factory of Hikers brand company by Polyacid Pipe Industries, in which instead of putting its own brand, the pipes are being manufactured and sold by putting illegal ISI mark of Jain Irrigation Company and Super Jain as well as other brands, in which the name of Jain Irrigation Company is getting tarnished and consumers are suffering loss. So, my lords, in my humble submission, this entire allegation does not satisfy the ingredient of 420 or 467, my lord.
Go there at this stage of charge, or move appropriate application for charge. Okay, after hearing the counsel for at this stage, after hearing the counsel for the we are not inclined to entertain the present witness. However, we look at the dismissal of so and so. What we hand a case, they can raise objections.
Great.
May I please, your lordships? My lord, it's an acknowledged consensual relationship, my lord, on the false promise of marriage. My lord, there is a first closure report was filed, marriage took place, my lord. Subsequently, my lord, they continued live together for some time instead of withdrawing that matter, and once, my lord, the IO submitted the closure report. Then, my lord, she said that I want to proceed with this matter, my lord. Subsequently, I approached to the Honorable High Court. Honorable High Court should have granted me, my lord, the further trial of the court proceedings, my lord. Stay of the trial court proceeding. Honorable High Court, if your lordship would see the impugned order for a moment. Plus, may I?
Yes.
May I please, your lordships? Kindly come to the page number 1, my lord. This is.
You are so early coming fast here.
Yes,
So that not said anything.
Ultimately, summons have been issued, cognizance has been taken. I have been summoned, I have been called to appear, my lord. A summoning order I have placed on record. Your lordships kindly come to
What would happen then?
page 81, my lord.
Yes.
I will face trial in a matter which is, my lord, purely consensual relationship, and, my lord, the High Court on once. Yes, kindly come to, my lord, cognizance order, page 81. May I read, my lord?
What was your petition before the Allahabad High Court?
Which was for quashing, my lord.
You say that it was a consensual relationship. Either the other side may come and say, yes, it was a consensual. Otherwise, at this stage merely on your defense. This question can be directed Mr. Dubey.
It's not a case, my lord.
Yes.
Because here, if you, that's why my impugn order has to be seen for a moment, my lord.
What is the order which you are challenging today?
Because that's the.
Please, what is the order which you are challenging?
Because Honorable High
With
Court.
that order.
Yes, my
With
lord.
that order.
Yes, my lord. Yes, my lord. My
What
lord.
order you are challenging?
Shri Vishal Pandey, Learned Counsel for the applicant. Shri Raghavendra Pratap Singh, Learned Counsel for the opposite party number 2 is present and seeks time to, this is prosecuting counsel, file counter affidavit and submits that the allegation of victim is the accused applicant has entered into a marriage merely to weaken the content of the FIR. He further submits that divorce proceeding is also pending between the accused and applicant and victims. He seeks to file counter affidavit. My lord, 1A, what I am seeking before your lordships, that my application be decided. What High Court should have done, my lord, on the very first day, they should have heard my application, my lord. This order says, while issuing,
Application.
my lord, the application for stay, my lord, kindly come to,
Consider, we'll say.
my lord, page,
Okay. Let me consult for the petitioner and just said the order. Dated. What is the date of this order?
that is 16/3/2026, my lord.
16/3/26. So which case has been fixed in 23/3/26. It is the contention of the petitioner that the application for stay has not been, application granting stay has not been decided. However, the court may look into this same. Court may call upon the said application and pass appropriate orders at the earliest.
Time period we fixed with great respect, my lord. Otherwise, a 24-year young boy, my lord.
We should issue the direction to the High
No,
Court.
not direction, my lord. With great respect, my lord. With great respect, your time, if a man, 4 weeks at least, say, my lord, that would help. My purpose, my lord, 4 weeks, my lord.
Thank you. Nothing can be done.
Grateful, my lord, deeply hopeful.
Pass over in this.
That one of the person who was not a party came to this court in SLP number so and so, which was not entertained. However, after hearing in a counsel for the petitioner, taking that the issue appears to be a larger for a society in the state of Maharashtra, we issue notice in this SLP, returnable in 8 weeks. Delay conveyance button. Are you accepting notice, Mr.?
I am accepting for respondent number 5 to 8, my lord.
You accepted, my brother is saying that some issue is there.
Yes.
So we let us see the larger issue is there.
I was also going to submit my.
Are you agreeing this? We look into this some larger issue.
Sorry.
What the society says that one case, the person who was that party
has gone
came.
down.
We are saying, sir, that's all. We are saying.
But there was a petition.
We have said, sir, we are. उसको भी रेस्टोर कर लेना, उसको भी SLP को कनेक्ट कर देना.
No, 19/4 is the date on which there was a party which was before the High Court, which was also there before your lordship, 19/4. And 4 those special petitions were disputed. It is up to your lordship, no issue. But it was not only one which had.
What do you want to say?
The person which was.
You want to say dismiss it?
I am only finding a factually correct statement that person which was party before High Court, which had also come in SLP, which SLP is also there.
इसका एक वो मत लिखना. वो लिख देना, one SLP came, but looking to be that was dismissed. However, at appropriate stage of moving an application that may be revived. उसको बाद लिखना, वो लास्ट में लिखना, उसको ऊपर लिखना, since a larger issue is in after hearing so and so, और वो नीचे वो डाल.
Your Lordship, the mediation proceedings are still continuing between the parties. I request that the matter may kindly be listed sometime in July.
अब July, August.
July, Your Lordship.
July is some.
Your Lord,
Solar has given a time.
Your Lordship, I'm requesting.
Solar is given a time.
No, Your
It will
Lordship.
come in August.
I will apply.
Yes.
Lordship, I am seeking pass over in this matter.
My lords, my uncle was the original owner.
How much delay, sir?
Delay, my lords.
How much delay? How much delay, sir?
514 days.
14 days.
Yes, my lords. The reason being, my lords, the petitioner was unwell, my lords, and he is in a village. So the lawyer.
He was unwell for 514 days.
No, my lords. The lawyer.
Let him remain unwell.
My lords, may kindly hear on merits also, my lords. At
Let
least.
him remain unwell, sir.
And he stays in a remote village, my lords, in Karnataka. I could not.
That doesn't mean that.
No, I appreciate that.
For partition, you are contesting everywhere.
Yes.
And now, whenever it is to become in the Supreme Court, you have become unwell.
No, reason being, my lords, the lawyer who conducted the matter.
I don't know what is the lawyer did and what you did, sir. Nothing is there in
My lords, on the merit, my lords, otherwise,
nothing in merit itself is nothing is there.
no, the written statement of the defendant number 2, now I filed as annexure P1, my lords, it specifically says that there was a sale date.
Okay. Dismiss on the ground of, since no plausible bona fide explanation, sufficient explanation is available, dismiss on the ground of delay. There is a delay of 514 days, so I'm saying here. Next.
Oblige, my lords.
56.
56, I begin by seek my lordship's apology. My learned junior had been able to fish out in the morning. 2 persons were granted anticipated bail by the same honorable judge. Can I? She has been able to fish it out.
Can we give you another order? We have dismissed SLP of the co-accused having the similar role. We, in the same case,
This versus
you
that.
can take this also. But you have seen that, you can see this also.
That's- Another was the larger group. I belong to the larger group. If he is from the larger group, then of course I.
Case of then, sorry.
On the ground, they indicate lordship because of that. Lordship say
We
that.
need not to say anything, sir, in 136. We are not inclined to entertain. Finish. Nothing more. Thank you, sir. लिखिए list before a bench in which brother Justice Chandolkar is there.
Yes. Well, can it be on Friday or something?
Can we do, sir? The learned senior, when once brother is staying, can we do?
But otherwise,
Take a recourse with the registry. Next.
The suit is filed, lords, on primarily 3 grounds. Lords, non-payment of rent, nuisance and damage in 2015. Lords, in 2022, a new ground is added for bona fide need. Lords, the High Court, the trial court and the first appellate court, Lord, accept that and say there is a bona fide need. Lord, may kindly have page 4 for a moment. Lord, there is a statement which is recorded which says that it has come on record. Lord's 6th line from the top, page 4. In the oral testimony of the plaintiff, it has come on record that there are 3 rooms available on first floor, and as per submissions made by the appellants, there is a 3-storied hospital constructed by the plaintiffs themselves. But this is only a 5 by 5, 3 shops. Now their case is that they want to establish a clinic. Lord, the father is already a doctor, Lords, practicing in the city, Lord, for the past 30 years. But this plea is introduced after 7 years when they know the Lord.
How much time you want, sir?
Lord,
How much time you want to vacate?
Lord, may I have it, Lords, at least till the end of this year, Lords.
End of this one. Fine. Dismiss. Undertaking within 3 weeks, 4 weeks for them. In areas for condition to areas. Thank you.
Great.
26. Somebody connect. Yes, sir. Serial number 26.
Milords, I am appearing on the behalf of the petitioner, Milords.
Yes, please.
Milords, the wife and the two minor daughters, Milords, the petitioners are the legally wedded wife and two minor daughter of the respondent, Milords. Milords, their marriage was solemnized on 12th May 2011, Milords. Milords, here the issue is in respect to that the respondent husband has preferred a criminal revision 2952 of 2024 before the Allahabad.
Notice on Delhi as well as on SL. Thank you. Yes, sir.
My lord, my predecessor in interest, the revenue entry was in his favor, my lord, the possession was continuously in his favor. These aspects have not been considered, neither by the High Court or the three courts, my lord. I did raise this issue as paid in the review court also, my lord. The review court said that you are raising this issue for the first time here. It is completely incorrect. My lord, may kindly come to page.
Come on the merits, sir. Review.
Very well, my lord.
Come on the merits of the case.
My lord, for past 50 years, my lord.
Come on the merits of the case.
My lord, the first issue itself, my lord, page 85. My lord, may kindly see the issue number 1 in paragraph 7.
If we see in real, plaintiff with this Rachmalla one side and the defendant Pedda Venkash, and the another side is of the Rudramla Mutaya and Rudramalla Venkatesh.
Yes, my lord.
And both family, this is just like this. Both families given half and half, and now they want
My lord,
contest of this.
this is my
Concurrently court recorded against you.
the consistent case of
Yes.
my lord, but the consistent case of the petitioner here, my lord, that this land was, my lord, absolutely in my possession and my ownership with the title.
Sorry, sir.
Grateful, man.
Sorry, sir.
Delay, my lord,
One
against-
delay, sir.
delay, my lord, because
More
the
than 2 days.
original order, my lord, review order I am in time. Both the orders have been challenged.
Line delay control.
Great.
You must be happy and delay. Is why going from here. जी तो अलाउ कर देना एग्जीक्यूशन में प्रॉब्लम है 34
As I represent the respondents. Again, a case of regularization.
But the matter well is non-miscellaneous deal, or bunch of matters also they are seeking the regularization
NMD
also. That is by NMD law.
Well, it's,
due in August.
that's what they want, Alex. They've been working for almost 9 years now, Alex.
They are protected as of
We
now.
are not saying anything. We are not deciding. We are thinking, let it be in NMD after.
Yes.
They want to take a chance at appropriate place.
Absolutely, Alex.
Take it. No problem.
In 35, taking a Passover minutes.
Passover.
Yes.
36.
Your Lordship seeking a Passover.
Six. My lords may have it on a NMD, my lords. Readings are complete.
It will go on NMD.
Great.
September no कोई date लगाना है. 37 there is a lack of. 38.
38 I am requesting for accommodation, but I tried to circulate a letter, but it
This one, that side.
Lord, I am appearing for other side.
Have you filed a counter affidavit?
No, Lord, I have to file, but it's a short point. My Lord, Vinita Sharma has taken care of this already, and the judgment in case of Prakash versus Pulvati and Danamma, that has already been overruled. Therefore, this point is already considered. Kindly see para 8 of the impugned order, my Lord.
You don't want to file counter.
My Lord, I will file if your Lordship say, but
No,
it
we
is,
will not say anything, sir. If you are interested.
I will file. I will file.
That you are not interested to file counter affidavit.
Let it be, my Lord, second week of July. Third week.
September will happen. Okay. Yes. Meantime, counter affidavit will file 8 weeks counter, 2 weeks remainder.
Grateful. And
May I seek up for a passover?
I would like to be on record, but in any way, documents are recorded in any case. Will have to go on.
May kindly pass it over.
Will have to go on.
It will take time.
Malas, it will not take time. Malas, a very short issue involved in this. Malas, it is very short issue. Malas, the only issue. Malas, may kindly time. Malas, that's the only factor. Malas, it's just a very small issue, Malas, which is involving about that. Malas, date of service, Malas. A date of service is the only issue. Malas, my respectful submission is Malas, may kindly pass it over.
Item 40.
Please, Your Lordship. Your Lordship, I have filed my wakalatnama.
Madam,
Please, Your Lordship.
why you don't go for mediation?
So we can explore the mediation if it is.
Mediation to kar dena.
Please, Your Lordship.
41.
Lordship, second passover. Seeking a passover, madam.
41.
Yes, Lord.
42.
Within 42 also I'm playing for a passover.
42 passover.
Please.
Albright complying.
43.
Lordship, the learned senior has logged in, Dr. Sophia Begum, she's logged in.
What is?
Logged in, Your Lordship, she's on BC.
Logged in.
Dr. Sophia Begum.
May I please, Your Lordships? Please
Yeah.
coming up for the instructions of the respondents, my lords. In fact, Your Lordships wanted to dispose of this matter.
Yes.
Malas, in item
Sudhir Mahato versus State of Bihar.
Yes.
Yes, sir. When to the connected judgment, Malas applies on all fours. In fact, for the other accused, Malas, it was her house allegedly. In this case, he was found at the place allegedly. So it applies on all fours, Malas. I'll leave it at that.
Instant appeal. Is at present he is in custody.
Yes, my lords.
Yes, madam.
How much years, sir? 15
But
years.
15 years, inclusion of remission.
Judgment of conviction sentence. Judgment लगा हुआ है मेरा. बस ये जजमेंट से इसी में कोई अपील तो ठीक है. So in criminal appeal 1051 same judgment. Arising out of the same judgment dated so and so, the present appeal has been filed. Full stop. This indeed not in dispute that the court is Gauri Mehto and Gauri Kumar, alias Gauri Kumar, while criminal appeal number so and so before this court, where appreciating the entire evidence with the judgment dated 27th of February 25, acquitted the accused. Full stop. Learned counsel appearing on behalf of the respondent is unable to make any distinction to the findings as recorded by this court in the said case. Full stop. Considering the same and applies the both findings in the case of so and so with its mechanism in this case.
Yes.
To acquit the accused so and so, he be released from the jail. Baki will liख देना if he is not required in any other case. Allowed in this court. Thank you.
Grateful.
44.
Your Lordship, appearing for respondent number 7, State of Tamil Nadu, Your Lordship. There's a government change in the.
But I am for.
There's a government change in the state, Your Lordship. Respondent number 7, State of Tamil Nadu.
Tamil Nadu.
Yes, Your Lordship. We're seeking an adjournment on that behalf.
Court should change
Yes, Your Lordship.
because of the government change.
Government change, Your Lordship. Government change is.
For 44.2, Lordship.
I'm sorry, Your Lordship, I couldn't hear that.
Lord, in this, Lord, I am appearing for 44.2.
Let's see here.
Lord, medical.
Please.
Your Lordship,
We used to have some wit and humor in this.
Lord, Union of India and Medical Council of India is the party in this.
Not she is stating. The regime is changed in the state.
apologies, Your Lordship, I couldn't.
We are not saying madam anything. We have just put certain usual
My apologies, Your Lordship.
on the request of counsel appearing on behalf of State of Tamil Nadu. List. इसको कर देना after past 13 days.
Lordship, if a date will be given. Your Lordship, could any date in July be given?
Fixing a date, not Madam, July you can understand.
Lordship,
If I am there, I can understand. I am putting on myself a burden, but I cannot put a burden to others.
Milord, we have completed the course, Milord. The 4 years BDS and was covered by your Lordship judgment, 2000. Any short date?
Fixing in August. Anything else? Earliest.
Much out.
July, 1 week only.
Great.
Plane is 1 week working.
Great, Lord.
That week you know this will not be heard.
Yes.
So better in August, we are fixing some date.
Much of.
But madam, come this is a matter relating to an admission, nothing can be done. As much as you will make a delay, it will be a problematic.
The new
Finish it
government.
as the earliest.
Much of.
45. Yes, madam. Who is appearing in this? 45.
Your Lordship, counsel for the respondent is appearing through VC, Your Lordship. Counsel for the respondent is appearing.
In this matter, Lord, I am appearing for the respondent, Lord.
Yes.
Lord, I am fighting for more than a decade, Lord, this case, Lord. High Court has allowed the writ petition and has given the clear-cut finding that the disciplinary authority has violated the provisions of law, Lord. And on that ground, Lord, CAT order was set aside, Lord.
Clear this case. Who is for the Union of India?
Lord, on many occasions, Lord, they have sought the time from this.
Lordship, I am requesting for a passover in this matter on behalf of Union of India.
Please, Your Lordship. Lordship, I am for the petitioner, my lord. Please, Your Lordship, my lord.
Yes.
My lord, I am for the petitioner, my lord.
You are for?
I am for the petitioner, my lord.
Yes, madam.
My lord, this case actually, the petitioner was suspended on the basis of the false FIR, and later on it was found that it was false. So for 3 years he was remain in suspension, my lord. He is asking only for the regularization for the purposes of the pension, my lord. He is already retired, my lord. He is already 66-year-old, my lord. So this is the only request. High Court has already
For the pension.
for the purposes of pension only.
This is order, no?
My lord.
This has been directed.
Yes, my lord. The High Court has allowed, but government has again rejected that. High Court has impugned in judgment.
Where the government rejected, where is that?
My lord, that already within 3 months they had to give it, but they have not considered it, my lord. After hearing of the petitioner, but they have not considered, they have not even. My lord, 3 months, more than 3 months have gone. They have not considered. They have not considered him. He has already given representation, my lord.
You are for
I'm for the petition. I'm for.
petitioner Vijay.
Yes, my lord.
Yes.
My lords, we don't have any instruction whether it has been rejected or not, my lords. My lords, in 1996, he has been suspended, my lords, and found that it's a false case. He has been reinstated and the absence period was regularized and he was asked to join on a duty on a particular day, my lords. Then he went into CAT and asked that due to mental harassment, I couldn't able to work in this district. Let me post it in some other district. That also has been granted by the tribunal. Even after granting that, for a period of more than 1 year, he didn't join that, my lords. However, that also has not been considered for a barrier for a promotion. He has been promoted as an inspector grade and he retired in 2017, my lords. In the meanwhile, he filed a OA in the tribunal for regularization of that period, which he has not joined as per the tribunal's order. That has been rejected because there is no valid reason why you have not joined. Then again he filed a writ petition before the Honorable High Court asking for a regularization of the same period which he was remained absent for no reasons. That has been allowed by the single bench. Upon appeal,
what do you want to do now? Please tell us.
My lords, everything has been granted, my lords. Can kindly see the tribunal's order, my lords.
This period, have you treated this period as a dial zone?
My lords, it has been treated as non-duty, my lord.
Non-duty. So have you regularized this period counted for the purpose?
Only
grant of pension?
for pension, it's not, my lord.
Why not, sir?
Because
Until you say it's a dice zone, you cannot cut out this period. You have to count it.
my lord,
Have you said so?
my lord, that rejection order was not on record, my lord. Only the review rejection was there. The reason that was annexed P1, it's a review against the rejection that has been annexed.
Seek instruction and finish it.
I'll do it, my lord.
You are the Union of India.
No, my lord. State.
Fighting for no reason, sir.
My lord.
It would not make any difference.
But the only
For
concern
the
is,
sake of fighting, you fight it. As usual, as state Kerala does.
State has lot of.
Otherwise, nothing is there in this case, sir. Until you pass an order of dice zone of this period, you have to regularize this. And this will be counted for the purpose of pension. Or otherwise, you have to take an action that this period you remain absent. So we are holding an inquiry for this absent, unauthorized absence. This is a misconduct. We can understand these two recourses we have taken. Otherwise, regularize, nothing third option.
we'll take it.
Okay. We have the in the counter affidavit filed by the state, nothing has been specified regarding the directions as issued by the head. So, for reconsideration, regularizing the period. Full stop. It is to be noted here that in absence of passing an order, in absence of an order of dice zone or holding the inquiry of the absence period, it ought to be regularized. Full stop. Counsel for the state may seek instruction and file additional counter affidavit within 4 weeks. This regard. Finish it, sir. No reason.
My lord, they have already regularized, but stating that it will not be considered for pensionary benefits. That is what they are saying.
For the purposes of the pension. Thank you. 47.
But filed an application for inflictment. It's running in the list for the board. Petitioners will have to.
Go in NMD. Okay.
Your lordships, I appear on behalf of the petitioner.
Maybe lordship may grant leave in this matter.
Which case?
47.
Why?
Better.
No meeting. This can be heard, sir.
Very.
This can be heard, Kunal. Nothing is there in this. Much more.
Your lordships,
48.
your lordships, I appear on behalf of the petitioner in this matter.
Well, I would like to appear for the respondent. My lord, may I seek some accommodation today? I was a little unwell, if my lord may permit.
Your lordships may fix it for final hearing in August or September, your lordships.
Grateful, my lord.
49.1, there is a letter.
I said, I requested for it.
I said, you circulate.
Yes, madam.
Let it go after.
Sure. Let it be NMD, Miller. There's already an order.
NMD.
Much obliged.
Wait, please, the lordship. Section 50 CDs are complete. Lordship may fix it on an NMD in August. In some date, my lord.
51.
Or 50 some date, my lord, August, September.
August, September. 50 NMD. Space will take them.
Manoj,
51.
I'm appearing for the respondent. As such, this is a consent order. As such, this is a consent order in 51.
Come on NMD, please. Make your submission. They are not going against. 51, sir.
51, my lordship.
51, I'm saying it's a consent order as such.
Okay.
My lordship, the family court has not granted the divorce because there was no cruelty or decision on the part of wife. My lordship, the High Court has granted divorce only on the ground that it has been 20 years they are living separately.
Go for mediation.
Mediation, my lordship.
Better go for
No
mediation.
problem, my lord.
57.
May I please, Your Lordship. Lordship, the only issue on which there was agitation in High Court was the 6 months notice period. The tenants are sitting in property for more than 40 years. At this juncture, we are ready to give them 6 months if they vacate thereafter. Rest, everything is decided in my favor.
My lords, the matter is already set for pre-lok adalat for tomorrow by the Supreme Court.
It can be disposed of today.
Although Mishra, Madam Mishra, Prachi, it can go, then Lok Adalat can get it done.
My lordship,
I mean,
You are offering,
I'm offering 6 months.
you seek instruction, madam.
my
Tomorrow
lords,
then I will.
we need time to file the counter too.
9 months they have taken to file counter.
My lords, we filed wakalatnama.
4 weeks time to file the counter affidavit is allowed. Full stop. It is informed that the matter is coming in the Lok Adalat. However, the parties may seek instruction to and to apprise in the Lok Adalat regarding vacation of the premises. Full stop.
My lords, just a humble request, my lords, if the time can be extended to 6 weeks as the main council just suffered a heart attack past month only.
Now 4 weeks you are here now. You can get it done.
But you can give a date. I mean, tomorrow we'll appear before the Lok Adalat, but if it doesn't get settled, a date before this honorable court.
Then on the Lok Adalat you can ask traffic. What we
As your
do
lordship.
today.
As your lordship. Deeply obliged.
Yes.
Please, ma'am. Sanitation workers.
Subsequent development.
There also, I understand, but there is a change in dispensation. Your lordship also knows that.
We don't
Have it in July. Have it in July.
Sanitation.
For 5 minutes, your lordship may have to, this may not require what he's saying. My lords,
I have not said anything.
the present application has been filed by temporary employee working for 10 to 21 years.
Except this 53.1, it's a different 53.10.
That's RSLP. Now what has happened, that board is also, that recruitment board is also now stayed, struck down by the High Court. It's being considered by the lordship.
This appears to be different matter.
I understand.
Yes, my lord. We have sanitation workers, my lord.
So other cases are concerned, we are adjourning to the August of interim order to continue. Yes, sir. What do you want to say? Interim order to continue. What do you want to say?
By the clock, my lord, just the thing is that they have been working for 15 to 21 years. In the subsequent development, it is served by lordship judgment in power.
Nothing doing, sir. Let it to be examined. We have understood.
My lord,
Has been stepped down. Now we have to look into in that context. We are aware.
Look, just
Let
one
it be examined, sir. Now we
one request.
will
My lord,
53.10.
53. Is this, that my lord, your lordships are now hearing, my lords, an SLP at the instance of the board, my lords, against the order which struck down, my lord, section 9 validity. Let it be heard along with that, because unless and until they have power to
Then
request.
SLP is there.
Yes, I have the order. My lords, I have one submission, my lords. My lords, our case is slightly different, my lord, if your lordship may permit me.
That would be hard altogether.
Yes, my lord.
We are not saying nobody would be hard.
I give, my lords, we are all sanitation workers, my lords.
My lords,
Sanitation workers.
53.10, as my lords suggest, it is a different matter, my lords. Actually, I am demoted, actually. For the last many years, I am waiting for this, my lords.
At this point, devotion.
My lords,
My lords,
my lords,
only
kindly appreciate.
my lord, only submission, my lord. We are all sanitation workers, my lords.
December में लगा देना सबको along with tag with so and साथ में लगता है.
1st July.
21st of July is coming. Please come with so and so. The matter which is coming on 21st of July.
My lord, slightly paying one submission.
In order to continue.
My lord, we are all sanitation workers, my lords. We have been working for last 20 years in this establishment.
Denying sir to anyone you are.
No, I agree, my lord, but the fact is, my lord, our case is completely different, my lord. My lord, we have come in, my
Detect कर देना.
lord, we have been joined before the act came into existence.
Detect. We list separately.
Please, my lords. That may be listed end of July, my lords.
Sir, it is coming on the day on which the other case is coming. We are doing it all. Let it be said.
Yeah, my lords. My lords, because it's since it, my.
Thank you, sir. 54. 54.
Looks here, the pleadings are complete.
We'll go ahead and
Completely
end it.
taken up for
My lord, could a date be specified or,
Go in September.
my lords? Very good, very good. Public
But
notice.
sir, we are for this, we are
My lords, sorry, previous matter, interim order may be continued.
interim order to continue.
Great, my lord.
Mr. Parmeshwar, this matter is 27, at 4:15 for the state of UP also. The chief is inaugurating this. Alright, so it would be better on 27 means it may come on some other day thereafter. On tomorrow. It is coming. Tomorrow. The chief is inaugurating on that. So we'll list after. Like 28 is not a working. No, please. It's all right, sir. We did our job, sir. This is institution will go on. It's not necessary that I should do it. Any other judge will
taken so much pains in activating the website.
all right, we did our job, sir. You were a part of this. We did our job, sir.
Lordship, it has been operationalized. Module has been operationalized. I have filed the affidavit yesterday. My colleague is in the court with the copies of the affidavit because it has not come. 10 proposals at Central Jail, Agra, and 4 proposals at Lucknow have been processed.
Now, the first track you have won, which first tracks? Meerut, Agra and Lucknow, 3.
Lordship 2. Lordship said Central Jail, Agra and Lucknow as a pilot project. That has started.
We'll make it start with 2. All I can take it at 2. This affidavit may be taken up. मुझे इसका वो चाहिएगा. कल वो चीफ ने रखा हुआ इसका इनॉग्रेशन का. पहली स्पीच मेरी है उसमें. मुझे देखना पड़ेगा मुझे. I have to see, please put it in this. Oh, सुनो. उनको बोलना इसमें से सब ऑर्डर शीट निकालेंगे पूरी. उसको मुझे बताएंगे. Yes, friends. 59.
Pursuant to Lordship's order, we have made the complete payment on the last day itself, Lordship.
I have received the payment, Lord. She's, yes.
Yes.
On 22nd itself, she is appearing to VC.
Yeah, that's it.
Your Lordships have
उसका
permitted.
स्टेटमेंट आ गया क्या नीचे से रजिस्ट्रार के यहाँ से रिकॉर्ड हुआ होगा स्टेटमेंट आया रजिस्ट्रार के यहाँ से
The office reports indicates, Lordship.
kindly connect that girl
Yes, yes.
उससे पूछना पड़ेगा ना अमाउंट रिसीव व्हाट he knows English, huh? He knows English.
No, my lords, I have asked the learned
So my colleague was translating.
She will translate, my lords. She only understands.
She's asking. Rest of the. She's there. Baby.
Please kindly connect her.
She's there. I've asked her to switch on the video, my lords. She's there, my lords. I've asked her to switch on the video.
She's here.
No, she's virtually appearing. Lord. She's virtually.
But I've asked my colleague to ask her to switch on the video, my lords.
நல்லா இருக்கிறீங்களா இருங்க இருங்க ஒரு வீடியோ காலு அங்க ஆபீஸ்ல பேசுறேன்
Madam, you translate. You can communicate her. She knows. You ask, please, ma'am, please. You ask whether you received the entire amount of these 10 lakhs in total.
இன் டோட்டல் 10 லட்ச ரூபா உங்க அக்கவுண்ட்க்கு வந்துருச்சான்னு கேக்குறாங்க ஜட்ஜ் சார்.
வந்துருச்சுங்க.
She says it has been received.
You ask to get set aside this judgment in which conviction is there.
இப்போ இந்த ஜட்ஜ்மெண்ட்
This man is there.
இந்த ஜட்ஜ்மெண்ட் வந்து அவர் கன்விக்ஷன் வாங்கியிருக்காரு இல்லமா அவருக்கு அகைன்ஸ்டா வந்திருக்கு இல்லையா அது செட் அசைட் பண்றதுக்கு உங்களுக்கு வந்து ஓகேவான்னு கேக்குறாரு ஜஸ்டிஸ் இந்த கேஸ முடிக்கிறதுக்கு ஓகேவா ஏன்னா அவர் மேல கன்விக்ஷன் இருக்கு இருந்தாலும் அந்த கேஸ வந்து க்ளோஸ் பண்றதுக்கு உங்களுக்கு ஓகேவான்னு கேக்குறாரு She is saying okay.
All right. You were there at that time? And then when this statement got recorded, we were there. Settings. We will do it. We will set aside this.
Very grateful, Lordship, for
Conviction because of her
It's very
recording
good.
her consent.
Both young lives will get a new direction, particularly petitioner.
Anyway, let them live their life in their own way.
Plus, also one request, Malas, in the interest
of the government, Inspector of Police, State Representative.
Mr. Sabrish was appearing. Mr. Sabrish used to appear, Lordship. Sabrish standing person used to appear.
Tamil Nadu.
But somebody was appearing up till last date, Lordship.
Yes. You call.
I'll call.
Call somebody.
I'll call.
Otherwise, it is a problem. Another problem, they will come up with that. We have not been heard.
No, but when Lordship had recorded the statement also on the day of that hearing, they were present.
We are aware of everything.
Lordship.
But something must come.
Very good. Lordship can, will just.
Please call somebody. Somebody. You call.
Wait.
60.
Let's really wait for the honored attorney. Now let's keep it after Lordships are sitting after lunch.
I'm appearing.
Mr. Luthra is appearing through VC.
Well, in fact,
after lunch.
whatever my learned friend says, because now whatever my friend says,
Malaj, we have affidavit which we have filed, but which is not on also to be brought on record.
may I just say this, not we agree with what the attorney says. It's just that there's one page note which my learned colleague will hand over. But we agree with whatever the. I know.
Sir, there is also an affidavit which has been filed.
Yes, I've read the affidavit. We agree with your affidavit. A lot of work has been done, but the union has limitations, and that's why the attorney's suggestions will be very useful. On the last occasion, the solicitor may.
The note and the affidavit, Malaj.
Yes. We are agreeing with that.
We will sit after lunch and we'll see and we'll pass certain direction.
The learned attorney.
Not, I've given you a lordship a one-page note, and I mentioned there also what the union has sought.
We are coming after lunch.
Yes, but 2 p.m. Yes.
2:15 we are coming.
Right.
Three, 4 cases. Last week I have done. We are coming back. Coming back.